In the matter of the Queen on the application of Hoareau and another versus the Secretary of State for the Foreign and Commonwealth Affairs, part heard. Please note, no recordings of this hearing are to be made apart from those of the court. Thank you.
Good afternoon. I see that there are a couple of people who are participating in this who are neither the judges nor Sir James Eadie, whose microphones are not muted. Could I ask everybody, please, other than the people I've just mentioned, to mute their microphones? Sir James.
My lords, good afternoon. I hope you can hear and see.
Yes, today your image is moving.
Well, Roger, I think that's progress anyway. It means I shouldn't log on and log off again. My lords, I was going to deal with the other aspects of the right of abode challenge, in particular whether the right of abode was taken properly into account, and that is then going to move into the irrationality challenge, the various ways in which, or materiality challenge, however you want to view it, the various ways in which there were said to be errors in the decision making. Then I'm going to come to ICJ in the first block, then finally the ECHR, if that's all right.
Yes, sir.
So, on right of abode challenge, was it properly taken into account? And the starting point we submit is Bonku number 2, and the decision of the House of Lords that it was lawful for Section 9 of the 2004 order to provide that there should be no right of abode. What that meant was that it was then for Her Majesty's government to decide what to reconsider and how to go about doing that against the backdrop of that established lawful position. And the Divisional Court, as you know, found the right of abode challenge to be, as they put it, both unrealistic and wrong. And they reached a clear conclusion that the right of abode had not been approached irrationally. Judgment, paragraph 113, with the core reasoning really at paragraphs 124 to 128. And the key point, perhaps, in relation to this is that the contested decision was, in terms, neither to support nor to permit resettlement. And it rationally focused, we submit, on that central issue. And I wanted to draw out 3 aspects of that central issue, if I may. The first was that, as I've described, it was a decision neither to support nor to permit resettlement. The decision not to permit resettlement was a part of, or a necessary adjunct to, the overall resettlement decision. They were flip sides of substantially the same coin. See in particular Mr. Hayes' first statement on that point, paragraphs 217 and 245 in the second of the supplemental bundles of tab 88. In summary, the government did not wish to take on the costs both of the initial and ongoing setting up, in effect, of a new society in these islands, for all the reasons that underpin that decision, to which I will come briefly in a moment. The evidence showed that the government would face substantial financial liabilities in terms of infrastructure, in terms potentially of dealing with the breakdown of any resettlement, which was regarded as being a serious risk given all the circumstances, such that no unsupported resettlement option was available. And if you can't properly set it up with the thinking, you don't create that burden or potential serious burden by the back door. And they did not in any event want attempts to set that sort of settlement up half-cock, or to permit the adverse consequences, environmental and other, to that setup unless they were long-term viable. That would have led to the risk of unstructured resettlement with no guarantee, for example, of the persistence of third-party funding, private funding, which you saw being considered inter alia in the Whitebridge report, with unregulated impact on the environment and the potential for substantial and long-term societal and economic underwriting by the aware already that the Whitebridge report assumed that there would be considerable civic infrastructure, not that the third-party investors who they were thinking about might foot that particular bill. And fundamentally, we submit it was a question of political judgment, whether they were prepared to allow, the government were prepared to allow unsupported or minimal infrastructure, whether in the outer islands or anywhere else. And if that conclusion about resettlement was a rational conclusion, as we submit it plainly was, and I'll come back to those reasons in due course, it is, we respectfully submit, impossible to see how it could be irrational not to change the constitutional order so as to confer a right of abode, alter Section 9, repeal Section 9, and if they replace it with the opposite. In other words, a right to live there. They would be doing so in circumstances where there could be no resettlement, no reason to put in place a right of abode that could not practically be exercised. That's why the two are intimately intertwined. You can't abide if you can't realistically resettle. If you cannot resettle, there is no basis, and it is worse, misleading to assert or confer a right of abode. And it was for that reason, or those reasons, that we respectfully submit that the Divisional Court were right at paragraph 114 of their judgment to conclude, as they put it, that the question of the legal right of abode was inexplicably linked to the practicalities of resettlement in the Chagos Islands. And you will remember that it is perhaps on this point also worth reminding you of Lord Hoffman, again in Bonku number 2. If we just go back to the Core Authority Fund on tab 16 in one of it, go back to our famous paragraph 53.
Do you have the page number?
Yes, sorry, 444, my lord. All the fours. And as he put it, and on this point about the inextricable interlinking, as it were, and resettlement, picking it up between C and D on 444 within para 53, he said if we were in 1968 and concerned with the proposal to remove the Chagosians, with little or no provision for their future, that would indeed be a profound intrusive measure affecting their rights. But that was many years ago. The deed has been done, the wrong confessed, compensation agreed and paid. The way of life of the Chagosians led has been irreparably destroyed. The practicalities today are that they would be unable to exercise any right to live in the outer islands without financial support, which the British government is unwilling to provide and which does not appear to be forthcoming from any other source. During the 4 years that the Immigration Ordinance 2000 was in force, in other words, that is before the right of abode, Section 9, nothing happened. No one went to live on the islands. Thus, their right of abode is, as I said earlier, purely symbolic. If it is exercised by setting up some camp on the islands, that would be a symbol, a gesture, aimed at putting pressure on the government and so on. That's why we say positively misleading and inconsistent to reach, as it were, a lawful decision on resettlement of the kind that was in fact reached, and then give the impression that they have a right of abode, which means anything means a right to live there. It's a right not capable of being exercised or operated in law as a right, and that was dependent, for good and rational reason, upon government funding, and not merely government funding, but all the other strands that fed into the decision-making, overcoming the security concerns, dealing with the environmental concerns, and so on. And it is to be noted also in relation to this first aspect of this key point, that the demands that they themselves had consistently made, government pay for the necessary infrastructure and support to enable resettlement to proceed. And as Mr. Fitzgerald, who was then representing appellant number 2, said below, it would be unthinkable that there was no support structure provided by the government. And it is in any event, we submit, whatever Mr. Fitzgerald might or might not have said, is unrealistic and irresponsible for a government to conclude that resettlement could occur without those mechanisms of support and without being prepared to take on the longer-term governmental responsibility for this remote island community. The second aspect I wanted to draw attention to is that, of course, the right to enter is distinct from the right of abode. But the case and the decision have never been about some split out of a right of this kind. It was about funded resettlement. And one needs to be a bit careful about what the appellants wish to elide. They have always demanded supported resettlement with infrastructure. And it's no good them then blurring that, as it were, into a right to enter, because it makes it easier to present the realities of what a right to abode will bring in its wake. The government was not obliged to consider right of entry in isolation from the demanded and the thing being considered, namely funded resettlement. The third aspect is that the government was well aware throughout that the right of abode was at issue, and also that the right of return was a potentially separate thing. The CCR summaries, which you have, if you want to put Lord Hoffman away and take up supplemental bundle, if you would. Tab 80, for example, on page 650. Those CCR summaries, and as you know, they follow in the tabs, show that ministers took into account the historic wrong and the value placed by Chagosians on resettlement / right of abode. Look, for example, at the very first bullet on page 650. And you see the same running through the summaries of the meeting notes in the other CCR documents going through to March and later in 2016. And so we submit that the Divisional Court was right in paragraph 212. If you just take that up with their judgment, it's Core Bundle tab 21. If you need, haven't got it separately, they were right to conclude as they did in paragraph 212. As they put it, the appreciation of the opportunity to right a great historic wrong which removed the Chagosians from their homeland was at the heart of the debate led by the Prime Minister and the driver behind what was a voluntary exercise. And citing the NSA's briefing to the Prime Minister of February 2015. Which chimes exactly with the points I made yesterday and don't repeat about the clear steer from the Prime Minister to see what could be done, which both sides have emphasised. Moreover, ministers and the Prime Minister and the Cabinet knew that the right of abode was at least legally distinct. Section 9 of the 2004 order and Bonku number 2 had been lived through, and lived through in tolerably recent memory. They were alive to the fact that there were legal issues around the right of abode, and that if resettlement was the decision, there would be a need for changes to the local constitution and the local law. If you put bundle 1 of the supplemental bundles away and take up, bundle 2 away and take up bundle 1, if you would, and go to the KPMG report at tab 16, page 99 is the start. The bit I want to emphasise at this point is in the legal analysis, the legal wing, if they have one of the KPMG, and the page I want for this purpose is 124, the second paragraph on page 124, second sentence, it will, however, be necessary to prioritise the legal provisions which require immediate change in the event there is resettlement as a decision. So they're working through here what you would need to do if resettlement was the answer. One of the things you need to do is to have immediate change of some of the provisions that currently govern, including, see the last two lines on page 124, and the direct quotation at the top of page 125, section 9, which deals specifically and in terms with right of abode. And the topic is then returned to on pages 127 and 128, where there is about a page's worth of analysis of the various provisions governing nationality and the right of abode. See the title by the whole bunch on page 127, including specifically the sentence, the second sentence of the first paragraph under that title. As mentioned previously, these orders specifically exclude any person from having a right of abode in the territory from entering the territory without a permit issued by the Commissioner's representative, and so on to over the page, seeing how things might need to be and would need to be changed. And it is important for this purpose, and indeed when I come on to rationality, to note, particularly given my learned friend Miss Kaufman's throwaway remark that things might be buried in the text of the KPMG report, so you shouldn't pay too much attention to that in terms of assessing what ministers knew. The KPMG report was specifically drawn to the attention of decision makers. I'm sorry to jump around between the bundles, but if you have bundle 2 to hand, keep bundle 1 out if you would, because I'm going to jump between the two. It's just the tab numbers divide rather unfortunately. If you look at tab 80, back to the CCR summary of the Cabinet minutes on the 10th of March 2015.
Page number, please.
651 is the one I want.
Thank you.
And I want the final bullet on that page. So bundle 2, tab 80, page 651, final bullet. So that was March 2015. Unless anyone had forgotten about it, the document we sent you yesterday, which I'm certainly not expecting you to retrieve at a moment's notice, I'll give you the substance of it and give you the point so you have it if you need it. But that was an email that was sent around to all and sundry by the NSC Secretariat immediately prior to the March 2016 meeting, which, as you recall, was the one at which they discounted or decided not to pursue the resettlement options. And one of the things that was said, and it's page number 2457 if you ever find the document, in that covering email enclosing the documents, it said it is important that NSC members have had the opportunity to familiarise themselves with the underlying material supporting any decision. The following documents were circulated and so on to NSCO members on the 4th of March, together with the papers and slides supporting the discussion. Annex A, the KPMG report. B, NSC papers of the previous meeting, C, and so on. And then underneath the 4 bullets and the 4 annexes identified, it said the 2 most important ones are attached here for ease of reference. They are the feasibility study, ... So exactly the same specific invocation to ministers, as you saw in the final bullet on page 651, was repeated immediately prior to and as part of the circulation of the minutes of the documents to be read in advance of the meeting in 2016.
Can you just give me, please, the reference to that email again?
The email, my lord, I'm sorry, I think it was a separate document sent to you, so, but I've got on the bottom of it page 2456, 7 and 8.
Yes, but which, and what, the supplemental bundle? Supplemental bundle 2. Must be.
Well, it may be, or numbering. Can I find out what that was? But
Yes.
It was sent as a separate email attachment the other day.
Yes, I just don't know whether my clerks put it in the bundles or not.
No, it doesn't matter, and the 2456 numbering doesn't appear to tally terribly well with the supplemental bundles, at least. So it may be just previous page numbering.
All right,
Anyway,
we'll try and locate it. The email is dated. What date is the date of the email?
The date of the email is the 14th of March 2016.
And who's it from and who's it addressed to?
It's from the NSC Secretariat, Cabinet Office,
Yes.
to a whole bunch of ministers.
Thank you. That's fine.
No private officers.
Thank you.
It's the ministerial right round, effectively.
Oh, I see. Yes, thank you.
Does that make sense?
Yes.
And my lords, just to finish this point, the ministers also knew that the right of return was at least theoretically distinct and had been specifically left open, and as being not the same necessarily as a right of abode or a right of residence. Going back to the first of the supplemental bundles again, and go to tab 37. On page 357. And again, I think I'm right in saying this is March 2016, so it's the same meeting, but I think these may have been documents from a bit earlier. But anyway, they feed into that decision making. They're in that clutch of documents. You will note that one of the options being considered on page 357, behind tab 37, is option B, no resettlement but right of return brackets not resident. And if you go over the page to 358, can I just invite you to cast an eye down paragraph 3, capital A at the top of the page, and then paragraph 11. It's reference to right of return without abode. So 3 on page, top of page 358, para 11 at the bottom of page 359.
Right.
I'm only going through this documentation to make the relatively narrow point that ministers were well aware from all of the documents I've just shown you that there were various aspects to all of this: right of return, right of abode, resettlement, and all of that. And legally, there were lots of things that were distinct, floating around and being thought about. But fundamentally, the decision making turn, for entirely understandable reasons I've already been through, on a central focus on resettlement. And that is also the answer to the case if it's put in this way, which it appeared they started from the wrong place. They should have used a right of abode as the key starting point. But the right to live where they are not living currently, under tenable conditions, is resettlement. That's why the decision was not to support or to permit. And that was because they rightly recognised, the government, certainly rationally recognised, that the right to live needed to be properly supported. Indeed, the appellants themselves appeared to recognise that, because that was the very case they were urging on the government. And that was the responsible governmental approach. this, we're going to do this properly, otherwise there would be a responsibility attached. And a bare right to abide when you couldn't practically exercise it is either no right at all, or the assertion of something which is worse and misleading. So then finally, in relation to this, and before moving to the resurrected rationality challenge, there was some pretty muted, compared to what happened below, reliance on the dicta of the Supreme Court in Bonku number 4, at Lord Mance and Lord Clark, that you will recall Miss Catherine taking you to yesterday. Bonku
Sorry,
number
can I
4
just go back? Can I just go back a little bit, Sir James? Because I want to catch this point, because this is a separate point that is raised by the appellants. So I know you've referred to a lot of documents, but this document at page 357 to 359, tab 37 of the supplemental bundle, is helpful, I think, to try to understand this point about if you don't resettle us, still allow us the right to go back, even though we won't be able to live there, because it's of great symbolic value. I mean, Ms. Kaufman's point was, well, you know, some things actually are very, very important, even if they're symbolic. But what you're saying, as I understand it, is if we look at this document, that option was certainly identified as one to be considered. That's the first point, I think, that you're making. It was there to be considered. It's costed in B, I think, and then 11 on 359 sets out some pros and some cons in relation to that, though it's been redacted as to the final part. And one of the points is that Jostens have received full and final condition for removal. So, is that really, of course, attached to that, as your point, will actually really what they were pressing for is resettlement. What is clear from 11 on 359, it says it quite specifically, is that there is a viable non-settlement support option which could satisfy some Chagosians and mitigate discontent following a non-resettlement decision. I mean, is there anything more you want to add to that? If I sort of summarised it, it was there, it was an option.
You summarised it perfectly, my lord. I mean, bear in mind, this document was a document that was, I think, reattached, or at the very least referred to, in March 2016, but had been prepared for the March 2015 meeting. And I suppose the only other point to add in, my lord, is that there were already supported trips being put in place. And you'll recall that one of the things that the support package ultimately was going to facilitate was return in a broad sense, going back, visits to go back and so on for Chagosians. There's all the difference in the world between that and a right to return. Go wherever you want, whenever you feel like it.
Yes.
And the reason for emphasising that is because once one starts appreciating what is obvious to lawyers, as it were, there's a difference between a right and a liberty, you start recognising that a full-blown right to return drifts very, very quickly into resettlement. So
is your case then on this? It's not true to say it wasn't separately considered, it was. Really to succeed on this point, it has to be an irrationality argument that it was irrational for the government not to go for this option.
Irrational not to go for this option, which isn't really what has been said.
Well, that's why I'm trying to put it into a legal framework.
Yes. I mean, I think what they're saying is you shouldn't. I think they say you focused only on resettlement, and you paid no attention to any of the other possibilities. Well, this explodes that. Then I suppose the only thing that's left of them is to say it was irrational to place such a degree of focus on resettlement without splitting out some different form of return, right of abode, whatever it may be. And I've made my submissions about that.
Is there any other is there any other documentation which explains, apart from what we've got here, some outline of costing and some outline of pros and cons, is there any other document where the decision not to take up this option is expressed or explained?
Gosh, I can't remember at this remove, I'm afraid.
No, all right.
Sorry to interrupt. There are some slides at page 408 and 409 of this bundle, which seem to have really part of that document written up in slide 4.
Oh, well, I'm grateful for that.
Because you have do nothing, status quo, no resettlement, which are the sort of binary options that the appellants say was an error. But if you go through some of the slides, some of the text is a bit more dirt.
Yeah. Well, I can't remember is whether if one goes to the CCR, when one goes to the summary of what was discussed in cabinet meetings and so on, you go to those documents whether this is specifically picked up. But in any event, the factors that bore ultimately on the decision making were those set out in those documents particularly.
Can I just ask, you said that the document at page 357, which was 25th of February 2015, was provided for the March 2016 meeting of the NSC. Do we have a document that shows that?
I think what I said was that it was recirculated to the NSCO,
Right.
as officials group, in March 2016. And I think that the closest one comes to it is in, my note says bundle, tab 40, page 413, where the February 2016 NSC briefing paper cross-refers at paragraph 14 to attached papers including previous NSC paper of March 2015.
I've missed that. Which page was that?
That's page 430, paragraph 14. So it's a slightly kind of convoluted picture, but I think it's previous documentation being referred back to. I don't know whether this was then reattached as a particular document rather than being referred back to. But it certainly was circulated again to NSCO in February 2016. And referred to in the NSC briefing circulation.
Yes, thank you. I'm sorry I took you out of your way.
No, my lord, not at all. That's helpful. I was going to go to Bonku number 4. I was on Bonku number 4. And the muted reliance placed on Bonku number 4, which is in Core Authorities Bundle tab 20 if you need it, Lord Clark and Lord Mance. I can take that very quickly because it was the subject of a very considerable amount of argument below on behalf of the second appellant and has been virtually abandoned here in all truth. But in any event, we submit that the Divisional Court was right. And I can just give you the paragraph references and don't need to do more, I suspect, for this point. Right at paragraphs 115 all the way through to 127 to reject the attempt to say there was some lawful obligation or obligation as a matter of law on the Secretary of State to reconsider right of a vote specifically. 115 to 127 in the judgment. And all that's said now by Ms. Kaufman is that Lord Mance pointed out and said, well, the logic dictates reconsideration of right of abode. And my short answer to that is, it doesn't, if the premise is that resettlement will not be supported or permitted, which was the ultimate decision on resettlement. And in case that was thought to be inconsistent with Lord Mance does not suggest that the logic would apply then. In other words, if that is the premise, his logic was simply, and sufficient unto the day for the purpose of the issue they were considering there, which was whether or not to return Bonku number 2 because of documents not having been disclosed. His logic was simply that KPMG existed, and so resettlement would need to be reconsidered. And any decision could then be challenged, as we note. That's why we're here. It has been. I was then going to turn to the criticisms of the as I am in relation to anxious scrutiny. That's a separate topic. I'm now on what I've called the resurrected rationality challenge. And it appears now to be said two things. It appears to be put in two slightly different ways. The first is that if only the Divisional Court had applied the anxious scrutiny test, or if only the Secretary of State had, that's the way it's put, that would have made a material difference to the decision making. And or that there were, and this is the way the case was always argued below, and or that there were misrepresentations and or errors in the decision making, leading to the decision being irrational.
Can I just raise this point? I think on your first point, I'm not sure that's I may be wrong about that, and Ms. Kaufman will no doubt say if I am wrong. I think she said under questioning from us that it was sufficient that they hadn't applied the right test, that we didn't have to go on, and we didn't have to find that it would have made necessarily a difference. If you haven't applied the right test, then it has to be reconsidered again. But I may be wrong on that.
Well, I'm not sure that's quite right. And I'm not sure that's quite right because the latter of the points, the second of the ways in which I put it, was the subject of my procedural bleat at the outset.
Yes.
One of points in that section of the judgment for which no permission was sought or given.
Well, anyway, no doubts you can come back in a reply.
It was anxious scrutiny, and then it was said, well, then the Court of Appeal, Lord Justices Underhill and Leggett said in their judgments, you recall, well, you better identify how you say that's material if you say they got the test wrong.
Yes. Yes.
That is not going to affect anything. It's not going to affect the substance of the presentation.
No.
But for the purpose, the second of the ways of putting it, I simply remind you that the legal principles, health stores, and the E decision, if you'll remember about mistakes of fact, the principles were correctly summarised in the Divisional Court's judgment at paragraphs 214 to 216. I wanted to make 5 overarching submissions, if I may, about this part of the case, and they're brief submissions, and then I'll come to a little bit more detail, which will, I'm afraid, involve a bit of document bouncing, but I'll try and do it as efficiently as possible. But the submissions, first of all. Firstly, there was no error of law or principle by the Divisional Court, and none has been asserted about the test to be applied. So these are questions about whether or not the Divisional Court was entitled to reach the assessments and the conclusions they did on the issues that are now remaining as subject to challenge. Secondly, you will bear in mind that in that exercise, they were, if I may respectfully say so, particularly well placed, given the mass of material, given the time they had, given the full submissions they had on all the issues of fact, to make those assessments and judgments, as opposed to what might be, I hope not unfairly characterised as selective snapshots over the course of an hour or two by Ms. Kaufman. And the Court will be well aware of the principles set out in other places in 2018 in the AR and Greater Manchester Police decision by the Supreme Court, that even in the context of a proportionality assessment, an appellate court does not re-perform that assessment, but considers whether the reasoning of the judge below was justified. A point which might or might not be reinforced at this level in the not too distant future. Thirdly, in assessing the issues, however put, we submit that materiality is a key and necessary precondition to any successful challenge, even if there was error which we do not accept. And I emphasise that particularly in the context of this case, because this was a decision into which a myriad of evaluative factors fed. Repeat the submissions I made earlier about the standards and the respect and all of that. But the Court would have to conclude that A, there was error or misrepresentation, and B, that would have undermined the decision that resettlement. So they'd have to be absolutely fundamental to that, given the strands feeding into that. Fourthly, we positively submit, and I made the submission yesterday, so I'll just note it and move on, that whatever standard was applied, rationality, anxious scrutiny, even proportionality per Lord Carlisle, would have made no difference to the outcome. It would, on all of those systems, have afforded a very significant margin or degree of respect, akin to rationality, if not rationality, to the government. You would still have had various interlocking reasons for the decision. So if you're going to say it's material, it has to be something which realistically can be characterised as an element that they weren't entitled to conclude, should have been taken into account, or that would have fundamentally undermined the reasoning. It's that fundamental vitiating flaw that suddenly undermines this multifaceted decision, around the edges and trying to pick out particular points and assert error does not get them into the foothills of a successful rationality challenge. And finally, we submit there was no misrepresentational error for reasons I'll come to. But in order to place the specific grounds of challenge remaining into some context, and in order to provide at least the very briefest summary of the context in which you would have to consider those materiality points and some of those other submissions, I do just want to remind you of some of the key components of those core strands in the decision making. First of all, costs. No one disputes that costs are a legitimate, indeed a key part of any such reasoning. A pound spent in one corner is a pound removed from other areas of critical government spending. And note also that full and final settlement has been reached, at least with some portion of these appellants. So the moral call on the public purse, whatever the nature of the historic ones, is very considerably less than it might have been. Secondly, in relation to costs, there was no obligation on the Secretary of State for Foreign and Commonwealth Affairs to fund the resettlement. That had been the specific claim that was made in the Chagos Islanders litigation and was rejected by Mr. Justice Ousley in his decision, which you have in the Supplemental Authorities Bundle, page 284. See in particular for that purpose the judgment at paragraphs 123 and 747. And permission to appeal that decision was refused by the Court of Appeal, Lord Justices Sedley, Newberger and Judge, at paragraph 54, where they described in that paragraph that they said that whether or not a return is possible is, as they put it, a function of economic resources and political will, not adjudication. Paragraph 54, page 630 in the Supplementary Authorities Bundle. Thirdly, the costs in this case, in this context, for the purpose of considering resettlement and all the rest, were extraordinarily carefully analysed. You're well aware of the KPMG report and all the detail that it contained. You also need to bear in mind that the view of government, unsurprisingly, was that the KPMG figures were likely to be an underestimate rather than an overestimate, despite the many millions attached. See, for that purpose and by way of example, the CCR summary, number 3, Supplemental Bundle 2, tab 81, page 654 to 5, under the title Costs. There's an italicised title saying Costs. And of course the KPMG figures themselves were then subsequently, after the report had been produced, subject to yet further detailed analysis and consideration within government. See, for that purpose, probably the best and most efficient way is Hayes 1, Mr. Hayes around about page 716 following in the supplemental bundle number 2. Fourthly, in relation to costs, it is quite clear what the overall cost answer was. This wasn't a decision that was going to turn on the minutiae. The fact of the matter is that almost any number or set of numbers you choose to take involve many, many millions, whether by way of capital expenditure or short-term ongoing costs and liabilities that the government will be taking on as part of the setup, or you analyse it in terms of the longer-term governmental responsibilities that would necessarily be assumed by throwing their weight behind the setup of this sort of community. Doesn't matter which way you view it, these costs are very, very significant indeed. And for that reason we submit, you take up the judgment again, and you go for this purpose to paragraph 204, if you would. Mind you, just having a quick reminder of that. Core bundle tab 21, page 231 if you're electronic. Can I just invite you to read 204 to 206, or just refresh your memories of it? I'm sure it'll be in there anyway. As for costs, it starts.
Sorry, this is paragraph 74.
No, 204, my lord. I'm so sorry. On page 231,
Oh, I should say sorry.
we're in the section of the judgment with irrationality in the wider sense. This is the
Yeah, yes.
wide lens analysis. You'll recall it. 204 to 206 is costs.
Yes, I see it. Thank you.
Yeah. That's costs. Costs were A. B. Defence and security concerns. And again, I don't invite you to turn it up now, but C, by way of example, in relation to defence and security concerns, the CCR summaries, number 1, tab 79 of supplemental bundle 2, 646 to 7. Number 3, tab 81, page 653, which confirm the importance of the naval facility and the relationship with the US, unsurprisingly. Number 4, tab 82, page 658, fourth bullet from the bottom, for confirmation of US opposition to settlement and unwillingness to give practical support. It wouldn't permit tourism via Diego Garcia. It wouldn't permit any of that set of facilities to be used, including specifically the runway. And it expressed real concerns about the impact of resettlement on the utility of the defence facility there set up. And as Mr. Hayes points out, or notes in his statement of 117, Outer Island tourism may not have been opposed in principle by the US, but only if it did not depend on transport via Diego Garcia, which it might be thought was close to being a precondition to any viable thing, not in any event. And so again, if you still have the judgment open, you will see the structure of the judgment of the Divisional Court, because in the paragraph to the ones I just asked you to read, they deal with defence and security. Judgment paragraph 207. And we respectfully submit correctly, and indeed we note no challenge whatever is mounted to either costs or defence and security in the divisional. So two of the critical strands, or the two most critical strands it might be thought, are simply unchallenged before you. Thirdly, or C, concerns about the creation of a new remote territory, real concerns at a social level running through the decision making, and all the FCO and NSC documentation particularly focused on this. And again, judgment paragraph 208, correct and not challenged. And the same can be said in relation to the fourth or number D of the letter D of the key factors, the key strands, environmental considerations. I'm not going to take up long with it. See judgment paragraph 209. And if you wanted flesh on that bone, this was a subject which was of particular importance to and the subject of particular and detailed consideration by KPMG in their report. And I do invite you to flesh out, if you would, the bones on that particular paragraph in the judgment by reference, amongst other things, to the executive summary in the KPMG report, Supplemental Bundle 1, tab 16, page 107 to 8. And then they had a whole section of their report, section 5, analysing in considerable detail the nature of environmental damage that was risked by setting up either or both of the sort of infrastructure that would be needed or allowing tourism into that part of the world. And of course, this consideration is a particularly acute concern in relation to the outer islands option, because the outer islands are, in the briefest possible summary, super protected. So we submit that the overarching point in relation to all of this is that, if you still have the judgment to hand, is that paragraph 203 of the judgment is plainly correct and extremely important for your purposes. As are the related concluding paragraphs in their standback review of the rationality challenge at paragraphs 211 to 213. I just invite you to remind yourselves of those paragraphs. Before coming to the responsive case very briefly, I wanted to touch on the final, as it were, positive part of this context setting, which was that there was specific consideration and rejection of an outer islands only option. The structure of the judgment, as you've seen, was to deal with what they described about paragraph 201 as irrationality in the wider sense. And then they went on in the title about paragraph 214 to the specific challenges to the decision not to resettle the outer islands. So they then come to consider the specific challenge. And in relation to the outer islands, if I can just invite you to turn back to bundle 1 in the supplemental trial bundles, appeal bundles, and go back to KPMG report, tab 16, page 99, the electronic version. They rule out an outer islands option. They discount it on environmental and practical grounds.
So which page is that?
I think it starts at 105. And then go to 1, 2, 3. 105 is the final paragraph on the page. theory an option could be developed which was based only on outer island settlement, but this has been discounted on environmental and practical grounds. See section 5. Does my lord have that?
Yes, I do. Thank you.
Thank you. 1, 2, 3. So if we go forward as they invite us to do into section 5, we're going to pick 156. And I just wanted to invite you to draw a line next door to two passages. The first is the paragraph by the first of the hole punches on page 156. Although it doesn't think anyone's going to imagine the hole punches. Under 5.4.2, option 1, in general, completely undeveloped remote islands and demanding environments and so on. Can I invite you to read from there, just put a line from there down to the second hole punch, 2/3 of the way through the next paragraph. That gives you enough of the flavour, I suspect. So you'll recall that one of the reasons for discounting it was environmental, and the other one was practical, which I'm assuming takes in costs. I'm not taking costs, but it certainly, they conducted considerable analysis of cost. Can I invite you to keep that document open, if you would, and then get the annex to it, which is in the second of the bundles, rather inconveniently, and right at the back of that in tab 99. But Justice Dingemans now to click around in the electronics, but I want tab 99 of the second one, or the appendices to the KPMG report. 1283. Is the start of some detailed analysis of airports and runways. So they do a specific detailed section of their report on airports and building an additional airport on the outer islands. Part of that. 1283 is the start of it. See especially 1291. When they start comparing and contrasting what it's cost other similar or locations in the world and how much it would cost to build airports and so on. 1291. Then see 1350. Where again there's a whole section at the beginning of that page, top of that page, first half of that page, considering seaplanes and distances from other airports that people might be able to get to more easily due to a seaplane option and all of that. So they're considering all aspects of it. And then 1377. To 1378. They start examining costs in some detail. So you've got a whole segment of the appendix to this report. If you put that file away and go back to 16, that's the first whole segment of it analysing costs. But the costs of airports and the practicalities of airports and ports are included in the main report itself. Let's go back to tab 16 and go for this purpose to 108.
Sorry, which page? 1?
Page 108.
108.
112. I'm not going to invite you to read them all now, but you'll see just flicking over the pages that you've got a whole bunch of analysis which include the costs of making an air link into the territory, option 1. Total capital cost estimates 423.3 million. Indicative capital cost without airport and breakwater option 1 only 190.2 million. So you've got all of these things being costed in the main body of the report. Those costs were then subject to some critique by the second appellant below and were answered in a statement by Mr. Moody of the Foreign Office. Just give you that reference if you need it. Moody 2, paragraphs 6 to 13, responding to the critique of KPMG costs. Paragraphs 6 to 13 of Moody 2, supplemental bundle 2, tab 95, page 866. If you're there, you might read 25 to 29 as well on the same theme. That was 25 to 29. On the same theme, but perhaps all you need for this purpose is judgment of the Divisional Court at paragraphs 44 and 45, dealing with environmental damage, and 49 and 50, dealing with costs. And this is in the section of their judgment analysing the KPMG findings. So that might provide you with more than enough by way of shortcut. And as you will recall from earlier on, ministers were specifically referred and invited to read the KPMG report. It's inconceivable they didn't consider the feasibility of an airport and its costs. Indeed, it's clear that they did so from all the various CCR reports that we've seen. The witness evidence also went on below to explain how consideration of this element was taken forward post-KPMG, especially in the light of the fact that Diego Garcia was unrealistic, given the US concerns that have been expressed in particular. A fact, of course, which also has a very serious impact on the viability of an Outer Islands option on any realistic basis. I've given you Hayes 2. For this purpose, the relevant paragraphs in Hayes 2 are paragraphs 19 to 29. Supplemental bundle number 2, tab 94, page 853. See also Ms. Moody 2, paragraphs 6 to 13. Again, I think I've given you that. Tab 95, page 866. So that was KPMG. You then had the Whitebridge report, on which Ms. Kaufman placed a little reliance. That's in the same bundle as the KPMG report, this time behind tab 31, page 282. And I just wanted to make some short points in relation to the Whitebridge report, just to put it properly in its context. The Whitebridge report was not commissioned to consider the wider economics of a resettlement option for the Outer Islands. Only the possible income and the possible costs for a private operator of a high-end tourist resort on one of the islands. See Hayes 2, paragraphs 19 to 22. Page 853 of the second supplemental one. It was a high-level, desktop-based report, unlike the substantially more detailed KPMG report. Secondly, and most importantly, the Whitebridge report's conclusions were predicated on the government paying for and/or underwriting the costs of re-establishing or establishing from scratch civic infrastructure on the Outer Islands. See Moody 2, para 12. page 868 in the second supplemental bundle. So the private investor options that are being mooted in the Whitebridge report all anticipate a ready-made infrastructure to support resettlement. So you'd have to create, before you get to Moody, to roads, power stations, water plants, civic buildings. It would all have to be paid for or underwritten. There is no suggestion anywhere in the Whitebridge report or anywhere else that there was any private investor appetite for incurred capital costs of the scale that we see being considered in the underestimated figures in the KPMG report. Indeed, the report notes that it's highly unlikely that a private investor would be interested in bearing those sorts of costs. Thirdly, the Whitebridge report did not look at the feasibility or cost of building an airport or a landing strip on one of the outer islands. See Hayes 2, Paras 25 to 27. It dealt with runways at a very high level, without expert aviation input and with no costings, as it itself fairly acknowledged. See for this purpose page 309 in tab 31 of the first bundle. But perhaps again all you need for that is paragraph 228 of the judgment. So it didn't look at the feasibility or cost of building an airport or a landing strip. It looked at what it described at 309 as preliminary thoughts on possible lift solutions. And it confirmed at 314 within that a high-level assessment of the possible options is all that was done, and specialist aviation advice would be needed.
Sorry, can we just have a look at? Can we just have a look at that? Can we just have a look at that? Because we're moving quite quickly.
Yes, sorry.
So 314 is the page on which the appellants rely.
Yeah. The second bullet, quick summary of our high-level assessment of various options need to be verified by appropriately skilled and technically competent specialists in the aviation sector. So they're not purporting to do any great analysis. Tourism specialists.
Well, I don't think the KP. I don't think that KP.
They were asked to do.
So sorry. So James, I don't think the KPMG said that you couldn't build an airport. They said it would be expensive. Is that right? Have I got that wrong?
They said it would be expensive, and they said it would carry enormous potential environmental costs.
That's right. Yes. Yes.
Remember, it was environmental and.
Yes.
I mean, in fairness, this is no criticism of Whitebridge. I mean, Whitebridge is being put in there to do a kind of tourism analysis, if that makes sense. Whereas KPMG are there to get down and dirty in amongst the actual costing numbers, and how you would go about doing it, and what the associated environmental costs might be. So one needs to be very, very careful.
So who commissioned this report?
I think it was government. Yes, it was Foreign Office. As you see from the covering letter on page 283. As I say, the Divisional Court dealt with the White Bridge report entirely and fairly. Paragraph 228. It's other places in particular. You see 228 and 229 they deal with the White Bridge and the runways on the outer islands. But that's the basic picture. As I say, I go back to it for all of the reasons I've identified, particularly to do with environmental considerations, costs, creating a new remote territory, and so on, and the outer islands option.
But how do you meet head on the point that in one of the sort of memos leading up to one of the meetings, I think the Security Council meeting, it simply does say, well, there's no possibility of an airstrip or an airport on the outer islands.
It's the Hyde Park reference, my lord.
That's right, yes. I mean, how do you meet that head
I come
on?
to that directly, because I was going to move from the positive case to the responsive case, and that's the first point out of the responsive case.
Yes.
The airstrip dealt with in the judgment at paragraphs 225 to 231, in our skeleton at paragraphs 75 to 78. And my submission is that there was a very careful consideration given to this by the Divisional Court. They were entitled to make the finding they did. There was no error of principle or law, and they weren't wrong. And the reason they weren't wrong is because, as they found, context for that statement is the key. KPMG, before that statement had been produced, the consultation had happened, and considered in terms the costs of building an airport to service the outer islands. So the judgment at paragraph 227, a critical point of context, is plainly correct. And the White Bridge report, as we've seen, was after it. It was after that statement, if we're focusing on the Hyde Park statement, but before the March 2016 NSC meeting. It didn't advance the core problems of cost or environment, as we've seen, but it did consider physical possibilities. Indeed, that was a significant part of the premise on which it was considering matters. And then, as the court below also pointed out, one had the slide pack.
Sorry, Sir James, can I just check what you said there? Did you say the White Bridge report followed after the minute of the NSC meeting at paragraph 225 in the Divisional Court judgment?
Have I got that wrong?
Yes. White Bridge was November 2015.
Sorry, you're right, it was before. I thought it was before. It matters not for the purpose of this point, it's just to be added in, as it were, to the list of things that were providing the realistic context, where everyone is considering the building of an airstrip on the outer islands. You're right, I'm so sorry, I don't know why I got those dates muddled, but you're right, it was 12th November 2015. So it preceded it. And what the Divisional Court concluded was that the Permanent Secretary's words were part of an overall briefing to the NSC, and the question truly was about whether or not it was realistic to build an airport to service the outer islands, and it was ruled out as a realistic suggestion, so it was reality that was being considered. And we respectfully submit that they were entitled to take that view. One doesn't construe these things as you would a statute. He was simply introducing the reality's question. Is it realistic to build on these islands? And they had a mass of material available to them, including the KPMG report, which they've been specifically invited to read, and the Whitebridge report, which my lord has just reminded me was probably recent. And they have the slides. There's no indication anyway that if there was any sort of error or misunderstanding, it fed in any way, shape or form to the decision making itself. This is just an ex post facto edifice ought to be built. There's no reference to this statement, Hyde Park or anything else. There's no reference to it in any of the CCRs. It's evident, on the contrary, that the key considerations that fed into the resettlement decision, were the combination of factors that I've already identified, including specifically in this case the lack of reality and the associated costs, economic and environmental damage, and so on, and all of that I've already made reference to. And none of those are challenged. We respectfully submit that read fairly and in context, that statement should not be taken, as it were,
Right, let's continue.
Well, I'm grateful. I was on the second of the specific grounds of challenge that have been picked up already, and that was the deliverability of the compensation package in Mauritius. And what I was proposing to do in relation to that was to take it very, very briefly, by reference in particular to paragraphs 251 to 253 of the Divisional Court's judgment, if you have that to hand. Page 242 on the electronics.
Yes.
I don't intend to go back to all the documentation that is referred to, but what I think it might be helpful for me to do is to just to give you some of the references to some of the documentation that feed into those paragraphs, just so that if you need it, you can see there was evidential support for each of the findings that were made. Para 251, the second sentence. That was the document that Miss Kaufman handed up, I think. But I'm not sure you really needed the hand up, because you will see if you go back to paragraph 244 in the judgment, that quotation is already set out. And you'll see that the point being made in 251 second sentence is that even at that high point of the Millennium Friends argument, as it were, the British High Commissioner of Mauritius's view in August 2016 is qualified in the current circumstances and as things stand. So if you go back to 244, look in the second sentence of the quote, which starts in the current circumstances. And if you go down 3 lines up from the bottom of page 240, so it's not feasible as things stand. Those were the words that were being picked up by the Divisional Court, correctly and properly, I submit, in the second sentence of 251. Then they go on to say at 251, the government was well aware of the risks of the delivery. There was no failure to take those risks into account. They were identified at all material stages, including the NSA's final briefing to the PM as an, quote, important matter. And in relation to that point and those documents, the NSA's final briefing to the PM, which referred to the important matter, is in Supplemental Bundle 2, tab 77, page 629 and paragraph 8. So SB2, page 629, para 8. And you might choose also to look in that respect on pretty much the same point at pages 626 in the same bundle. And then back a bundle, which is partly why I'm not inviting you to take up these bundles and follow the references through. But the final one in this little sequence is Supplemental Bundle 1, tab 70, page 602. So the Divisional Court say, going back to 251 of their judgment, no failure to take the risks into account. They were risks creating a current problem to future delivery of that part of the package destined for Mauritius. They say that for obvious reasons. You identify a risk today, it doesn't mean that a risk today translates into an impossibility tomorrow. And so you'll see that the NSA's view, the court goes on at 252, was that non-cooperation from the Mauritian government was a risk but not an outright obstacle. The defendant in October 2016 envisaged close liaison between governments to enable delivery of the package. I think that's a reference to a ministerial submission made by DFID to its Secretary of State in October, and the reference there is to Supplemental Bundle 1, tab 75, page 624. So then the Divisional Court goes on effectively to say, well, they identified the risks, they thought about them properly, they decided that they weren't forever insuperable, they recognised how important they were, and it was an evaluative judgment for them to make. And we respectfully submit that that's an entirely proper and appropriate finding on the materials and before them. So that's a short point in relation to deliverability. I'm going to bring before what was going to be the last chunk of my exhibitions, but I'm going to deal with it now because it fits most naturally here, I suspect, which is the amount of the support package, which was Mr. Jaffe's argument, if you'll remember. And that is dealt with in the judgment at paragraphs 300 to 324. As issue 6. And in our skeleton, para 67 to 71. And the second appellant does not advance this grounded challenge, you note, at the outset. And the case appears to be that ministers were misled on the basis of the figure of 40 million. The short answer is the same one I've just given in relation to, in principle at least, to the previous grounded challenge, which is that paragraphs 312 to 318 of the Divisional Court's judgment were grounded in clear evidence and were findings they were entitled to make. There was on this issue a really quite significant amount of documentation, toing and froing on all sorts of issues associated with the number, whether there should be a number, doubt about whether there should be a number unless and until it had been properly explored, including a visit to Mauritius to bottom out the needs and all of that. And ultimately the decision that was reached was ministers wanted, no doubt for obvious and understandable reasons, to put a number, if only indicative, on the amount of the support package that they were going to announce at the same time as giving the bad news on resettlement. And the number that was alighted on was 40 million. The key evidence on the development and consideration of that number and the various toings and froings that there were, as I say, it had started, I think, at 55 million. And Mr. Letwin had come in who had carriage of all of this, and he was thinking about a bigger number, and then everyone got worried because they didn't have the basis for a precise number. But all of that is traced through in Hayes 1, paras 249 to 294, tab 88 of the second supplemental bundle, electronic base.
Sorry, which are the paragraphs again? Hayes 1 paragraphs
249 to 294.
294. Okay.
And then Hayes, I'm going to give you 3 references into the witness evidence if you need it. Hayes 2, this time behind tab 94 in the second supplemental bundle, page 859. And the relevant paragraphs in Hayes 2 are 33 to 49. And then perhaps most significantly, given the way that this challenge is now being sought to be focused down, effectively trying to present it as though they did a needs analysis, it included 6 million for the Seychelles Chagosians, they took out the 6 million, ergo the Seychelles Chagosians were going to be shortfalled in terms of needs by about 6 million. C for that particular way of putting it is Matthew number 2, paragraphs 6 to 15 in supplemental bundle 2, tab 97, pages 884 to 887. And there were 3 key features that I would simply highlight. First of all, the 40 million figure was not a hard set figure. What was decided was the setting up of a support fund with an approximate amount to be worked on further and then to be distributed over a 10-year period. And so the Prime Ministerial decision of the 31st of August 2016 was for approximately 40 million. And we note 40 million for Chagosians in Mauritius, the Seychelles and in the UK. Supplemental Bundle 1, tab 72, page 608. And that reflected the previous ministerial briefing that there had been. The ministerial briefing to FCO ministers on the 25th of October 2016, supplemental bundle 1, tab 74, page 616, described it as around 40 million. And the submission to DFID ministers on the 2nd of November, at paragraph 9, supplemental bundle 2, tab 76, page 626, said that the 40 million figure was approximate and indicative.
Yes. What was that paragraph number again, please?
Number 9.
Thank you.
So it was a figure of 40 million that was not hard set. Secondly, and flowing on from that, nothing had been finalised at the date of the announcement of the decision on the 9th of November 2016, other than the approximate amount. It was clearly recognised in all the underlying contemporaneous documentation that the government would then engage in an exercise to determine how the support package would work. So only, if you will, the principle of a support package was decided as a matter of policy, with the approximate number and the detail of the policy of the package was at, quote, a formative stage, with a clear recognition that needs assessments, in particular, were still being carried out and would need to be bottomed out. See, for that purpose, Matthew number 2 in the paragraphs I've already given you, paras 17 to 25, and see also the passages to which she makes reference back in Hayes 1, 291 to 294. Third feature, there was a quite considerable discussion around the manner in which the funds for the 40 million or whatever it was ultimately going to cost were going to be provided and accounted for within government. And that depended on a whole bunch of complication which you don't need to trouble about, as to whether or not particular development funds could be used for particular purposes, or whether it would have to come out of general budgets, the sort of things that civil servants get extremely exercised about, but frankly don't make a ha'porth of difference in the real world, if the position is that it's not going to have a significant impact. Now, at one stage it was being suggested that all of that debate was going to have a significant impact, because at the heart of that kind of worry and that debate was whether or not the Seychelles were going to be sufficiently, I think it was their economic state was going to be at a sufficient level that they wouldn't be able to use a particular fund to get money to them, as it were. But the fact of the matter is it makes no difference whatever, because the decision that was arrived at, 40 million, yet to be worked through with all the details that was to be done, was clearly recognised by all concerned to be a number or a fund that was available to the Chagosians wherever they may be. See Matthew 2, paras 13 to 14, and the judgment at paragraph 313 was therefore entirely correct on that. So with those key three features in mind, the point about how precisely the 40 million number was arrived at ceases to matter. They're not prejudiced or cut out. No one is prejudiced or cut out. The number isn't fixed. It's a rough and ready number attached to that presentation purposes to the decision of principle that was announced. And just to make assurance doubly sure, we do respectfully submit the underlying documentation makes it clear that ministers were not misled. The Development Secretary and the Foreign Secretary knew perfectly well the basis of the figure from the submissions, the various submissions that were made to them. There's nothing to indicate that ministers anticipated that there was going to be a detailed needs assessment involving the Chagosians as a whole that would lead to a fixed number that could, as it were, never thereafter be broken. Indeed, on the contrary, all concerned knew that it was work in progress at the point of the November 2016 decision. hence the three features that I've identified at the outset. If you want a flavour of it, in terms of the ministerial submissions, you probably get it best from documents the day before the NSA to PM memo of the 25th of August of 2016, which is at tab 70, in a document 2 tabs earlier, and the day before that memo, at tab 68 of Supplemental Bundle 1, page 591. Again, I don't invite you to turn it up now, but you see all the themes that I've fairly sought to draw out being running through that document, including particularly the understanding at ministerial level that the figure isn't fixed. And they were not dealing with a beast in which you said, here's a needs analysis, and if you remove 6 million from the needs analysis, that's the end of it. It was far more provisional and fluid for entirely understandable reasons, not least the express and clear acknowledgement in all the documents running up, including those documents running up to the November actual announcement, that a needs assessment was ongoing and would need to carry on. And if you wanted specific details on why it was the specific reduction of the 27 million figure, which you'll recall was one of the figures involved, to 21 million, that's the 6 Mr. Jaffe was on that, why the specifics of that reduction do not mean, as it were, a diminution in the overall provision, because it was only provisional, or that they didn't mean that needs would not be met or could not be met as a result. Then see Matthew 2 in the paragraphs I've given you, Brian Matthew, second statement in the paragraphs I've given you. In particular, for her explanation between paras 6 and 15, on rebutting the point that the Prime Minister was misled in any way. As you will see from the documents I've already given you and from the statements in the passages I've already referred you to, the Prime Minister was just as clear as all her ministers that the figure of 40 million was an approximate or round figure of principle, and that further work was going to be undertaken even after the announcement of the decision. So for all of those reasons, we respectfully submit that there is no force in the attack on the amount of the support package. And also, I was going to move to the vexed question of the ICJ advisory opinion. It's not too late in the day to take on that bigger subject.
No.
And I start, if I may, with its status. Its status, first of all, on the international plane. It's an advisory opinion given by an international court in a non-adjudicative capacity and is not binding on states. Hence its title. There is provision for the production of ICJ judgments binding on the parties under Article 59 of the ICJ statute. And that effectively depends upon the consent of the states that are the subject of that case. So this beast, the advisory opinion, may only be requested by an organ of the UN, here the General Assembly, for its consideration, and certain other specialised UN agencies you don't need to trouble with. It may not be requested by a state. See Article 96 of the UN Charter. The fact that it is not dispositive and does not bind even in international law or even the states most closely associated with the issues that are being considered is one of the reasons why an advisory opinion does not give a, quote, decision, a dispositive, but instead gives a reply to the questions asked. It does not decide the case, but states it is of the opinion that. See, for example, the formulation at the end of the judgment in paragraph 183. Authorities Bundle 36, page 1724. And as I've indicated, and as the advisory opinion itself acknowledged, paragraph 85, the distinct contentious jurisdiction to give judgments in disputes between states is fundamentally founded on the consent of both states to that process. Second thing perhaps to note about its status on the international plane is that views expressed by individual judges do not form part of the opinion. These are views that are not accepted by the majority and therefore have, we respectfully submit, very little or no persuasive value. Thirdly, the General Assembly's reaction to the advice that does not convert advisory into binding. Indeed, it reinforces the political aspects of this sort of process. An attempt was made to suggest that you could use the GA resolution as somehow enhancing the legal status of the advisory opinion, and that we respectfully submit is wrong. The GA resolutions are non-binding and recommendatory only, and the General Assembly, as you know, is a political organ of the United Nations in which state delegates negotiate and vote, and its resolutions are not legal findings.
I think it was only suggested that its persuasive value would have been less if the GA hadn't accepted the opinion, but since they did strongly, its persuasive value therefore is greater. I don't think it was said that it has any impact upon its dispositive effect.
Well, my Lord, for the reasons I've given, I'm not sure I would accept that, or the converse, as it were, if one has a helpful AO opinion to a particular issue, that it makes any difference that the GA has approved it or hasn't approved it. Fundamentally, it's a political body, and it makes recommendations.
That's entirely correct. I mean, even the opinion refers to certain GA resolutions as being capable in international law of having normative value. I'm not suggesting this does, but resolutions can have an effect. I would not dispositive, not binding on this court, not binding on the United Kingdom in this context, but I mean, to say it doesn't have any persuasive effect is quite strong.
Well, my Lord, perhaps all I need for this purpose is Article 10 of the UN Charter, which provides in terms that it may, quote, make recommendations to the United Nations or to the Security Council. And that, of course, as you're probably aware, stands in contrast to the sort of resolution that we were discussing in the Supreme Court in the Sardar Mohammed case, namely UNSCRs, in other words, United Nations Security Council resolutions. And that is because under Article 25 of the Charter, members of the United Nations, quote, agree to accept and carry out decisions of the UNSCR, in other words, the Security Council resolution. And that was part of the argument in Sardar Mohammed. It was effectively said, here we are, sitting in the context of, was it Iraq or Afghanistan, I forget, but we're operating under United Nations Security Council resolutions. And they do have, as it were, that sort of binding effect in international law. I don't want to overstate it, and all sorts of things may have persuasive effect, but it is important to recognise both that the General Assembly is a political body and operates in the way that it does, and that even under the UN Charter, which governs the nature and effect of what it does, it is a body that makes recommendations, and that isn't a word chosen by accident because it stands in direct contrast with the phraseology that governs the binding nature, effectively, of Security Council resolutions. That's it.
What's the relevance of the word demand in paragraph 3 of the resolution, which demands that the United Kingdom withdraw its colonial administration within 6 months? Elsewhere, the resolution either affirms or urges and calls and requests, but in paragraph 3 demands. Do you say that has no different legal value to an invitation or an urging or a recommendation? delegation?
My lord, I do, and I do so on various grounds. The limit of the power of the General Assembly is set out in the Charter which governs it. See Article 10. So if you can have a recommendatory demand, well, you have a recommendatory demand. But it is not a demand in the sense that English lawyers would understand it.
Yes.
So that's the status on the international plane. So far as domestic law is
Oh,
concerned.
sorry, can I just take that up? We were shown various references, I think, in ECHR cases to advisory opinions of the UN, where notice had been taken of them. What do you say about that?
Well, I'm going to come to that when I get to the ECHR. There will be questions around the extent to which it actually makes any bones for the issue you actually have to consider, which is what is the true meaning and effect of responsible under Article 56.
Yes, but mine's a slightly different point, which is because you're saying that this is of no legal significance, even on the international plane. But what we were shown might suggest that actually international bodies, international legal bodies, adjudicative bodies, don't simply treat them as of no significance whatsoever.
My lord, I hope I didn't express it quite as absolutely as that. I certainly accept that there are some decisions in the European Court of Human Rights and the CJU as well, where reference has been made to advisory opinions and indeed to General Assembly resolutions. So I can't put it as high as saying no international court or adjudicative body has ever paid any attention to this. My point is, however, one of significance, because it is important to understand precisely how the internal structures and how the constitution of the UN itself works in order to appreciate what sort of beast we're dealing with. Now, it's up to other international bodies and adjudicative bodies included in that to decide how much weight they attach to these sort of opinions and or these sort of resolutions. And there are undoubtedly examples of the kind my lord puts to me. My only and short point in relation to General Assembly resolutions is that they are recommendations effectively by a political body, and that the advisory opinion part of it is what it says on the tin. It is an advisory opinion. In relation to both of those things, the resolutions and the advisory opinion, there is in the UN structure a direct contrast which highlights the lighter nature of those beasts. There's a direct contrast because in relation to advisory opinions, there is a process for getting binding judgments from the ICJ, but that depends on the consent of states. And in relation to resolutions, the contrast is with the United Nations Security Council resolutions, which the member states agree to accept and carry out under the Charter, Article 25. That's all.
Thank you.
So far as domestic law is concerned, an advisory opinion as such neither creates nor supports either the existence or breach of any domestic legal obligation. It is not a source in its own right, at least. I'll come to CIL in a moment, custom international law in a moment. It's not a source of common law to which English courts should have regard. It's an opinion on a question by a UN organ in order to assist it in its functions. It's not an adjudication between states. It's simply an opinion given to the General Assembly. And you see that from the judgment itself, from the advisory opinion itself, Para 81, where the court notes that its opinion, quote, is not given to states, but to the organ which is entitled to request it. But I don't want to overstate that point either, because I think the case that is being made against me says effectively, well, it's setting out and acknowledging rules of customary international law, and those may have some impact on domestic law through that route. And I think is the way the case is being put at its foundation against me. And so I turn to the rules of customary international law, and there are two stages to the analysis. Is a relevant rule of customary international law established by the advisory opinion, is the first question. And if it is, should that rule of customary international law be incorporated into and or have influence on domestic law? And there are two different stages, and it's important to recognise that there are two different stages. In relation to the first of those, is there a relevant rule of CIL created by the advisory opinion or the advisory opinion plus a General Assembly resolution? I wanted to make some points under that first head, and then I'm going to turn to reception. 3 points, if I may, under that first question. Firstly, the advisory opinion did not express any view on the existence of a right of return/resettlement under international law for Chagosians that could be enforceable either against the government of the UK or, for that matter, against the government of Mauritius. And that is why it said what it did in paragraph 181. It's core bundle 30. Perhaps ought to have it as well. We're talking about the judgment. It's in the second of the authorities bundle. Authorities bundle 2. Tab 36. And I was at 181 on page 1724. As regards the resettlement on the Chagos archipelago of Mauritian nationals, including those of Chagosian origin, this is an issue relating to protection of human rights. Those concerned which should be addressed by the GA during completion of the decolonisation of Mauritius. The fact that it, as it were, didn't find any sort of right of return or resettlement, and that was its conclusion in 181, explains the absence of any conclusions about resettlement in the reply. And the reply, of course, is at 183.
Sorry, 183.
183 is the reply, where it's summarised.
Oh, I see. Yes, I see.
You see?
Yes, thank
You
you.
haven't got any, it's an absence point. There's nothing about resettlement in there.
I'd understood the position to be slightly different. As I understand the judgment, question 1 was the legal analysis, question 2 was the consequences. The court expressed the opinion that the principal consequence it wished to address was this was a continuing breach, but as it sets out in paragraph 179, it doesn't assume the jurisdiction to tell the General Assembly what steps need subsequently to be taken to implement, as they say, the modalities of their opinion. And one of the matters which related to the modalities, which they didn't think they had jurisdiction to address, or they weren't going to address, was the human rights consequences. That's how I understood 179 through to 181.
But you need to read 178 as well,
Yes.
where they express the thing very differently.
I don't understand that.
Well, they're referring to that according to the United Kingdom's under an obligation, their conclusion, to bring to an end its administration as rapidly as possible, thereby enabling it to complete its decolonisation and so on. you have in 181 is
The
something.
modality.
Yeah.
I may have misread this, but I understood 179 then goes on to say it's not for the court to determine modalities, that's for the General Assembly. Then they talk about the erga omnes effect of the right of self-determination, and then they say it's for the General Assembly to, as it were, address this and work it out. So question 2 is concerned with consequences, but they propose a limit upon themselves as to how far they're going to go. I accept that they're not expressing a view on consequences here, other than in very broad terms. But I'd have thought one looked at the resolution itself to see what the General Assembly, I understand your point about it being politics, how they interpret the opinion and how it's meant to be implemented.
My lord, I think my point was a slightly lesser one. We may be we may be agreeing on cross purposes, if that makes sense. I mean, my point is a slightly lesser one, which is that they are not opining here on there being any form of customary international law right to resettle in the Chagos Islands.
And there may be, and on that limited basis, there may be a reason for that, which is they don't think that's within the competence of the second question.
Well, there may be.
If your argument is they had the opportunity to express a view about it, but didn't, and that's significant with regard to an issue. If you're saying they haven't, as a matter of analysis, expressed a detailed view on this, well, that seems to be correct because they remitted it, as it were, to the General Assembly.
Yeah, well, that's all they've done. They haven't said you have a right of resettlement. That's a necessary part. They just said a political wing should consider it.
It also may depend on how you construe 179.
It may depend on that. It may also depend on noting that the wording of the UN of question B refers also only to Mauritian nationals, which gives you some clue on what they're actually focusing on. This is about the decolonisation of Mauritius, is the point I'm going to come to.
Oh, understood. But just before we move on, I don't want to spend too long on this, but 179, not 178, which refers to decolonisation of Mauritius, which is the point you just made. This is about decolonisation of Mauritius, so it is, if you like, it's an issue between Mauritius and the United Kingdom, but it's the expression consistent with the right of peoples to self-determination. I accept it doesn't go very far. It depends into the analysis at all. But it lurks.
It lurks. It does lurk. There's no denying it lurks because they refer to it and then the GA pick it up and run with it. But it does no more than that. And the court's reference to resettlement was limited in at least 3 ways. It was limited to Mauritian nationals. It was limited to the responsibility of Mauritius. Question B, which you saw recorded and quoted at paragraph 1 of the judgment on page 1688. Question B asks about the inability of Mauritius to implement a programme for resettlement and so on. And it was limited to an issue to be addressed by the General Assembly during the completion of the decolonisation of Mauritius. That's 181. And you're right, of course, to point out, and we note that the General Assembly resolution, Supplementary Authorities, tab 60, page 3205, if you wanted, addressed in a non-binding manner. Paragraph 2F affirms the resettlement of Mauritian nationals, including those of Chagosan origin, must be addressed as a matter of urgency during the completion of the decolonisation process. Urges the UK to cooperate, but urges powerful. So again, lurking is not a bad word if I'm allowed to adopt it. It lurks. But it is quite important to understand what GA resolutions are, what their limited powers are, recommendatory, and that it is a political process. Anyway, that's the first point. Lurking at best, dealing of right of return or resettlement. One's looking to find some form of established without going through these points, is there some established customary international law right corresponding to the sort of claim that is being made here, which is to make the UK government resettle. Also for all of these reasons, the different second point in relation to whether there's a relevant rule of customary international law. The scope of the opinion is confined, we submit, the opinion is confined to relations between the United Kingdom and Mauritius in the context of decolonisation. In other words, this is about the right to self-determination during the transition of Mauritius to independence. And it's in that context that they express limited and circumscribed views that the process of decolonisation of Mauritius was not lawfully conducted in 1968 by reason of the separation of the archipelago. The UK is obliged to bring its administration of that archipelago to an end as rapidly as possible, is the phrase used. And that there is an obligation to cooperate and so on the UN. But the advice is on questions of public international law in the context of decolonisation, where the bilateral relationship between the UK and Mauritius is in issue. That's why B, addressed to the court by the General Assembly, was concerned with the inability of Mauritius to implement the programme. That's why they cast the right to self-determination as a right to self-determination, quote, in the context of decolonisation.
You accept that the opinion expresses that the principle of the right to self-determination as having a customary law character.
My Lord, I do. There is some controversy about precisely when it became a rule of customary international law. And that is a controversy that inures.
Would that make any difference to this? Well, after all, it's perhaps we simply read the opinion and see what they say.
Yeah.
But that's paragraph 160.
Determination here of Mauritius, not any alleged right of the Chagosians. It's a right of self-determination of Mauritius applied to the territory as a whole. It didn't find a CIL right of return and resettlement to buyout of the Chagosians. And that does, we submit, illustrate a quite fundamental flaw or difficulty in the arguments that the appellants advance. They seek a remedy in this court, in these proceedings, which they hope, with your assistance, will lead to the UK assuming the burden of establishing and funding resettlement. And of course the difficulty with that is that it precisely assumes the UK exercising sovereignty and administering the buyout to achieve that aim. And that isn't merely not supported by the advisory opinion, but runs directly counter to that advisory view. And Mauritius may not agree. And they didn't decide they had any rights against Mauritius. So there's a fundamental disconnect, not merely between the remedy sought here and this advisory opinion, but to the right that's being asserted.
In making that submission, I don't understand you to be saying you accept the analysis of the International Court of Justice.
My Lord, I certainly don't. The reason you were...
Taken details there, isn't there?
Well, there may be, but you need to test the argument. How much support does this judgment actually provide?
I don't
to the
know
case
well, so.
here? That's the only point I make. And of course, the reference to self-determination as, quote, a fundamental right was confined to the right to self-determination. It's back to the same point, para 144 this time, in context of decolonisation. That's the second point. The third point is the advisory opinion did not opine that this right of self-determination or to self-determination was a peremptory norm of international law.
Sorry, could you say that again?
Yes. The advisory opinion did not opine that even that right to self-determination was a peremptory norm of international law, or in the Latin, jus cogens. Remarks to that effect were made by 3 of the 14 judges, but only in their separate opinions. Judges Sabutini, Tinde, Robinson, and Cansado Trindade.
This is the right of self-determination of the Chagosians.
No, I think of anyone, of Mauritius either.
I'm sorry, I thought you had accepted an answer to a question by Lord Justice Green that it was accepted that the right to self-determination on decolonisation was a matter of customary international law. Did I misunderstand you?
We're now talking about the precise status it has under international law, whether it's a peremptory norm or jus cogens. And in relation to that, sorry, I may have misspoken earlier, but in relation to that, there was a finding that it was of that character, but only by the 3 judges who wrote their separate opinions, and had not, therefore, obviously persuaded the court to include that. And that's no doubt why the appellants in this appeal seek to rely on the International Law Commission articles. And so far as that is concerned, they are at the bundle of in the bundle of authorities, back end of bundle 2, tab 39. And 40 on those. The bit I want, sorry, is in the tab before. Tab 38, starting on page 1886. I'm rather hoping you might have had some additional documentation sent to you with which to feed in to this tab. Do you have 18871 through to 18877?
This is supplementary bundle of authorities.
No, this is the main bundle of authorities, tab 38.
Right, core bundle of authorities.
Core bundle, sorry.
Yes. Got 38, yep.
Is that Article 40?
It's Article 40.
Yeah.
And the commentary on Article 40. And I'm hoping you might have 18871 and following.
Yeah.
I don't know whether that's made it onto the electronic screen yet. So 18873, if you've got that, is Article 40.
Yes, I think I was emailed it separately.
I'm very grateful. And what I really wanted was paragraphs 4 and 5 in the commentary to Article 40. The structure and form of this is the ILC. They don't need any introduction, I know, to the court, but Article 40, this chapter applies to the international responsibility which is entailed by a serious breach by a state of an obligation arising under a peremptory norm of general international law. And then it defines serious in 2. And you'll see in paragraphs 4 and 5, a second column on page 18873 and over the page, if I can just invite you to read those. So you'll see that there's, as it were, a gradation, if you will, between paras 4 and 5, going down towards the lighter end at the back end of paragraph 5. And that in relation to the particular right to self-determination that we're thinking about, to the tail end of paragraph 5, first column on page 1887/4, and simply on the basis that it deserves to be mentioned, whatever that means. But it's quite looked down on the pecking order, if that makes sense. Noting that it wasn't the right listed in the ILC's commentaries to Article 53 of the Vienna Convention on the Law of Treaties. But in any event, so that's less than ringing endorsement of that as a freestanding peremptory norm. But in any event, the right being spoken of here is to self-determination in the context of a former colony becoming an independent state, not a right to resettlement or abode of supposed people. That's what the advisory opinion was dealing with. So the short point we make is that the position under CIL is that the advisory opinion does not establish or support any relevant rule for the purposes of the public law challenges in these cases.
Right, I understand that point. Can I just go back, because I just want to have clarity on this. In the advisory opinion, at 152, our attention was drawn to 152 and 153. It says the court considers that Resolution 151415 has a declaratory character with regard to the right to self-determination as a customary norm. And then it goes on in 153, it has a normative character. Now, I'm not quite sure how you're classifying that.
Well, my lord, it may not be entirely necessary to classify it finally, because the reason for taking you to the International Court Commission analysis is to indicate that there's at the very least a question mark about whether an international a right to self-determination of the kind that they're talking about is a peremptory norm for the purpose of attracting the rule in Article 50. Sorry, in Article 40 that we've just looked at. But the point in any event in relation to this is that whether it is or it isn't properly so to be characterised, it is a right to self-determination in the context of a former colony becoming an independent state. It is not to be equated, therefore, with a right to resettlement/abode of a people, in inverting commas. Hence the very different treatment, hence the focus of what they were actually analysing in this judgment, and hence paragraph 181.
So can I record your position then on behalf of the respondent as saying that whatever 152 and 153 may seek to mean, it doesn't. What we can say is it certainly isn't clear that it amounts to a what you describe as a normative, a peremptory normative rule. And even if it did, and even if it was purporting to do so, what is clear is the peremptory normative rule only applies, as it were, to the former colony as an entity.
Exactly so.
Right. Okay. I understand that.
Well, that might be a convenient moment. I see I've run over a little bit, and I think I'm in pretty decent shape for tomorrow. We've got a bit left to do in relation to this. I've got to deal with the impact on common law, which won't take very long. It's about transposition. And I'm going to translate it into some submissions that directly go to anxious scrutiny. And then I've really just got the ECHR to deal with.
Yes.
You've got my timings. I'm hoping everyone else is on this basis as well. I'm planning on finishing, so as to allow my learned friends. I think with Miss Kaufman slightly overrunning, but we won't hold her to the entirety of that. I'm planning on finishing, I think, by 3:30 tomorrow, if we start at 2.
Very good. Thank you very much, and we'll start again tomorrow at 2 o'clock.
I'm very grateful.
Thank you.